How are you?
Thank you. I'm Lisa Simpson, the court reporter for today.
Hi, Lisa. I'm Kathy Robinson. I'm the internet G.
Nice to meet
Nice to meet you too. Thank you for helping us. Are you gonna be with us
tomorrow and Friday.
Friday?
Yes, and I think Monday.
Oh, awesome.
I think so.
Okay.
Yes.
If you need anything, just give me a holler.
Absolutely.
You have my number. Let me see if I have. Here's one of my cards. If you just need it.
Okay.
You have one of yours?
I actually,
Okay.
you need one or do you need a couple?
Just one. Just good. Yeah. Just in case anything happens, I can call you. So today, I know it says motions, but apparently everybody has decided they want to take a plea. So it's gonna be 2 pleas today.
Oh, really? Okay.
Yes,
thank
so
you
it
for
should be
letting me know.
fairly easy.
Okay, great. Okay, it's gonna be really quick then.
Yeah,
guess.
very quick and easy.
Yes.
I've already got the recommended sentence and I'm getting started on the paperwork right now.
Awesome. Which out of the 3 are taking?
Well, the third one, we're actually gonna have to reset that one.
Okay, gotcha.
The attorney, unfortunately has tested positive for COVID.
Oh, no.
Yeah, so, we're gonna reset that one.
Okay.
But the positions 1 and 2 are taking the plea.
Oh, please.
Yes.
Okay. Please call me, Lisa.
Okay, Lisa, call me Kathy.
Okay, thank you. Stephen Robinson. Stephen
Oh, really?
Robinson.
When was it?
Stephen Robinson. He's a
Your
attorney.
kid also, not your.
You
My
really?
husband's name is Steve. I'm not. Stephen with a PH.
Well, yeah. He's from, Eclectic, I know.
Okay. I'm from Baltimore, Maryland.
Baltimore,
I was about to say, wait a
okay.
minute now.
And usually that lineage is pretty true, I guess, my understanding. So it might be related.
His dad's family is from North Carolina.
Okay.
Mom's dad was from a place called Humphrey. Humphrey from Maryland.
Yeah.
Very country. I had
So
no idea. Maryland's so small, but it's got a country.
Yeah.
Yeah.
So I didn't know, I had no idea Maryland was like that either.
So I was just like, that's quite interesting. Yeah, and my son and my son and my husband.
Yeah.
So he's just. We're married to the same person.
Okay.
Well, she was and I am.
Okay. Gotcha.
Oh, goodness. They feel when they put it as far as conditions to a sentence, no drug. Like now, you're gonna be sticking with them every single day to make sure they don't take a drug or an alcohol. Public, drunkenness, that's one thing, but if they're sitting in their house or at a friend's house or whatever.
Yeah.
You know,
I know to figure it out.
want anything to drink? Water, coffee, or tea?
I brought this, I hope this is acceptable. I can wait more than
Oh, yeah. Fine.
Look,
We've got some pretzels, we've got like peanut butter crackers, we've got chips, peanuts. Trying to think of, we got cookies. Trying to think of everything in that closet.
that was like a nice array.
Oh, that's fine, that's fine.
Came from the Florida, rated our snack cabinet. Like that quarter came from the Florida, our snack cabinet.
Oh, hey, McGee.
Good morning.
Lisa, this is McGee, he's our deputy,
I'm
assigned
good.
deputy.
Security alarm check, 115, Charlie. Good morning, how you doing,
This
Deputy?
is Miss Lisa Sims, she's gonna be our
Nice
court
to meet
reporter.
you.
She's covering for Shauna.
Oh,
She'll be
okay.
here today, tomorrow, what's the day, Friday and Monday.
Oh, so she's gonna be spending some time with us.
Yeah.
Yeah.
Spend some time. You know, Shauna. Oh, she's on vacation. Oh, yeah, she was pretty close. She was scrambling to try
So she
to
definitely gonna
find
take
a,
some time.
yeah, she was scrambling to try to find a flight
Oh,
to
my
California.
Oh, my God.
On Monday. Rough year. Well, it's been fun. I mean, good thing, I appreciate that, but it was just, I was just like, you know, it wasn't like, I didn't know them, I didn't grow up with them, it was like a daily,
Yeah.
but it was crazy. I was just like, oh my God, I'm about to lose my mind.
Okay, yeah.
Well, parents were just, you know, everybody's freaking out, like, what is going on? Hey, lady, what's up? I did. I'll send it to you again. Oh, no, that's fine. You want me to, I'll send it to you again. Okay. All right. Yeah, so my last grandparent was, grandmother on my mom's side. She stayed with us until my girls were born in 2000. She passed away just before they turned a year old, 2005. It was just very, very How are you?
Wait for this month to be over with.
Just started, it's long money just before.
I know.
Say of this month.
Judge Lethbridge has a 3-day. Even though that's online. Both of those, off of those.
I don't have that, don't have all that, but I do, I'm trying to fill up.
Yeah.
This month and next month.
It feels like a lot of.
A lot of agreement, take medicine, vital food.
Seems like it's that last push.
Well, I'm not trying to do the last push. I'm just trying to help the people get out if they can get out or move on to the next area. They need to go.
Well,
To get them at least out of. Is your person here?
yes.
What? Okay. Thank you. Here. Sign. Either one of these, here, and this is her. When you're done, just put it over here. Or if you see Miss Jones. Miss Jordan? Okay, so if you just have a sit down for a moment, we're just gonna wait for Miss Jones to come in, and I have your paperwork and everything ready, okay? All right, thank you, sir.
Brother, make sure your cell phone turned all the way off from two, please.
All right, I'm gonna run back tomorrow. Okay. I'll be right back.
All right.
Good morning, Miss Robinson.
Yes, ma'am.
Hey, are these pleas going to be felony pleas?
You're loud.
Oh, I'm sorry. I didn't mean to be loud. I'm sorry. I think I think to be felony pleas.
Yeah. Yeah, you want me to send you the
What I was going to do is, if you could give whoever the person is that's taking the plea, could you give them my state cell phone and I can go ahead and get their information now?
okay. Okay,
And just,
Miss Jones hasn't gotten in here, but I'll give um Mr. Wilson your number.
that's the only plea?
No, it's two of them. It's one's for Mr. Jordan and one's for Miss Watts.
Okay. Well, if you could give Mr. Jordan my number, if he could step out and call me, I'll go ahead and get his information now. And then he could,
You okay, you meant the not the attorneys, but their
right.
counsel. Oh,
Yes.
sorry. I'm sorry. Yes, I will do that. I will do that. Okay, I got it.
Thank you.
Okay. I'm gonna give you the number to the probation officer so she can go ahead and get started with your paperwork, okay? All right.
Morning. Morning.
Hello, how are you? Miss Cole. Want me to write? Oh, okay. So we'll call them right here. Okay. Okay. And when you get finished with that, let me have that back so I can give it to Ms. Watts. Thank you. All right. I'll be right back.
Need some calendars from you.
Last count I have is on the 16th. You just don't show me no little what's up.
Oh, no. You know what? I've been trying to hold off before I send the rest of the calendar after the trial, because I'm still trying to fill those up.
Okay,
So-
go ahead and fill them up, because you know, I
Yeah, I'm working on filling those
cover
up.
y'all ears. The way I move these cases, I get on them, and I was like,
I
hey,
like it. That's
you need
this is
to-
what I do.
but I need them in
I've been
advance.
printing out these.
Yeah.
They're trying to print these out. I'm like, oh, I can go ahead and start getting paperwork.
Yeah,
together.
because I need it in advance so I can pressure them to do what I need them to do.
Yeah.
Because otherwise, they be waiting till the day of the trial
You
talking
know,
about,
Mr. Clark is gonna be out for
yeah,
days.
so give them to me as soon as possible.
Okay, then I will.
Can I get a water check?
Yes.
Thank you.
Let me see, because, other day, what was that? Monday, it was, there weren't too many in there, but let me check, okay?
Okay.
All right. You got the last one.
Okay.
Oh. Yeah.
Rise, Superior Court of Fulton County, Atlanta Judicial Circuit is now in session. The Honorable Judge Charles M. Eaton Jr. is presiding. Court will now come to order.
How are you? Miss Jones here, or is she, we're still waiting on her? All right.
I believe Ms. Catherine stepped out.
Okay.
Sorry, you need a picture chair like that. I didn't really think of much. His issue, I mean, he honestly does have seizure issues and he ends up in the hospital a couple times.
There you go.
I think we could just probably say, once he stabilizes and he can find employment. That's the only issue is the epilepsy. I'm sorry. They do, but it doesn't
You met Miss,
always work.
Yeah, well, we said hello. Yeah.
Mental health, right? One day it works and the next day it doesn't.
Chucky.
So let's do this. Let's do.
What you saying? I don't know.
Both, it's a nickname. You can.
Chuck is his, how he introduced you. This is Chucky.
He has just obligated to get fired.
Okay.
Uh-huh.
Is that like a new DA policy? The whole requirement?
Oh, that's my requirement.
Okay.
You got the last one? Oh, no, that's yours.
Sitting around doing nothing.
I
You gonna
understand
get
idle
more
hands
trouble.
are the devil's workshop.
So
I got
you need-
that.
You need to get her to do something,
Looks like the Groot. Did you see that? Did you see the Groot email? Just they've agreed to a bond, so we're gonna send him off to Arizona first. And I'm not getting into the details of the case, but Ms. Brew is gonna be pro se. Or she thinks she's gonna be.
adamantly object to that. Yeah, she's
Well, we're gonna, I mean, because she's out of state.
yeah.
I may end up specially setting it, but I mean,
Yeah, if you do that, Your Honor, I just ask that they remain in shadow counsel. Because that's just gonna be challenging.
well, we'll let Philip discuss that, but
She keeps saying Marilyn Primovich,
Yeah,
is gonna be helping her, and I'm like, I talked to her, and she was like,
she's the supervisor.
right, she's a supervisor, she doesn't even feel comfortable with it.
so what I told, your person,
Are you printing out the consent thing here?
What?
Never mind. Let me look at it.
Oh, yes, I am, I'm sorry, yeah,
Talking about the consent bond?
yes.
Okay, yeah. Let me see that. I'll take a look at that. I was gonna print it out myself, but if you
You
are,
know what, when you said, I thought you were talking about the case, the two we got going on for right now. If you want this to be edited or anything, let us know. Send it back to me.
volunteers, they get volunteers, so I don't need anybody to take volunteers. Church, they got soup kitchen.
I mean, the problem is, generally speaking here, I've actually discussed this with other judges. I mean, the shadow counsel, I mean, it's always referred to as during the trial, but what happens before that? I mean, are you speaking to her directly about plea negotiations or?
I don't know the answer to that. I don't.
You know, they usually start off pro se and then we run with that, and then we do communicate directly with them. But she had counsel, and so
The defendant sort of, one day she has her PD, the next day she pro se. So I'm gonna have the Feretta hearing with her and all that, but I'm just trying to understand that process as it leads up to trial.
yes.
Well, Your Honor, I am currently dealing with that problem in another
Yeah.
case of mine, where I have been, I did not want to be supporting counsel, but I don't see any case law that says that the judge can't make me be supporting counsel. So Judge Lethbridge has basically assigned me as supporting counsel in that particular
You mean
case.
even prior to the trial, or?
So I withdrew from the case.
Because I've been reading lots of case law on it. It's been interesting that, there was one case I read where then, of course, they turn around and try to say ineffective assistance of counsel, and they lost that because they said, well, you refused it. He was brought in at the last second just to help you with procedures. So, I mean, but it was sort of interesting reading all the case law.
Well, I think in my particular case, it's a little bit of a special circumstances. So my former client, who I'm assisting with, claims to be a sovereign citizen. And so,
I've had those. That's different.
There's a whole different.
Yeah.
I've had those in front of me, but yeah, I pity you for having to be, I've not had representative counsel yet. It's not been a serious enough. But I think all of my sovereign citizens have been like foreclosure actions and stuff.
this particular person it's not.
So they're not getting shadow counsel in a foreclosure proceeding, so.
This particular person doesn't necessarily have the most serious of allegations against them. It's just he has refused to speak to me. He's refused to speak to court, and so
This defendant, trespassing an obstruction charge where they tried to remove her. And I know the plea that was presented to her is misdemeanor plea. Not on mine. So, but I'm just trying to think that through, because I've never had that situation where it goes through, I expect the trial's not going to pass more than a day.
Yeah, day or two, just speak to jury and then have the officers come in and testify and the manager. So I really don't want to, you know,
What?
it seems like she's a nice young lady. I never met her. But I'm hoping that they can talk to her and convince her to do something besides.
Hang on. No. Okay.
Yeah. hopefully.
Yeah, well, you know, but I think those attempts have been made, maybe, you know, new person and then see over there.
Yeah. Because, you know, like they say these days, it's all on video.
Well, I was assuming that there was video.
Yeah, it's all on video. And it's not gonna get better for her. So, you know, I just think that she has some issues that she needs to address, and I don't think her parents are helping.
I remember, that's mother, she sent me an email as well.
Whenever she's in the courtroom, the group never talking, it's the mother that's talking for her. And
It's frustrating because I keep getting those emails and
Yeah, you have to forward to us, and
Session with intent, is that 5 to 30?
no, I don't think so.
that wouldn't be the first one that wants to be placed.
What do you think? Lou? I know the max is 30. I don't think it's 1 though.
I don't think it's 1, but I don't think it's 30.
You know, Elizabeth has, well, we have a civil client. Very similar.
you're not doing it.
I think in my backpack, that has my little red book in it.
You know, I hate drug statutes.
How's Phil doing? Is he?
I think he's fine. I'm fine, but I'm obviously taking precautions. I'll probably test tomorrow. They say you should wait 3 days, yeah. But I feel fine.
16.
But I'm pretty much caught up on my vaxes. I haven't had the most recent one. I was gonna go this weekend and get it. Now I don't know. Because I don't know if you've been exposed, if you can get your vaccine. I have to check on that. I have no idea, but
I don't know, for the last, whatever it's been, 2 years, I've been tested 20 times.
yeah, me too. I mean, I've never,
People say, oh, you've had it, like my buddies are like, you're not exactly a specimen of somebody who's. But as far as I know, I've never had it. I mean, I've had family members of mine around me like coughing all over me, and I've never had it. I got tested like 2 or 3 times during that.
I'm similar.
I did get vaccinated in the beginning. I haven't kept up with it.
Yeah, I have, but also because we've been to Europe and other places in Japan where they
They're more
require it.
serious about checking it.
Yeah, they require it. So, and it doesn't bother me. I'm not one of those weirdos.
Well, I don't think I'm gonna grow a third eye from it or anything, but for whatever reason, whenever I get it, it feels like somebody punched me in the arm really hard for a couple days, so.
Yeah, I hear you. It was weird too, because COVID was going around the Air Force Academy and Grace felt sick. So she got day rest and she tested, but she tested negative, but she's like, I have all the symptoms on my other ones, but I'm testing negative. I'm like, I don't know what to tell you, sweetheart. Just put on a mask and go about your business. So I don't know, but he's feeling okay. Oh,
I'll just put it on the record and,
But,
yeah, let the judge know that we're gonna ask for, like, go with the label. Kind of statute for it.
no, it's PWIP. Is it 5 to 30? I know it's 30. The minimum. I want to say it's 5.
yes.
5. Okay.
I would take the word for it.
That's what I thought too. So we're trying to figure out the minimum mandatory for possession with intent. I didn't bring my little red book. My key.
So
Yes.
is Mr. upward?
He's got a record.
Okay.
I'll double check on that.
He
Um,
doesn't
No,
have
no, no,
much.
I'm doing the paperwork now.
So both of them are taking pleas, right?
And also, he's fine with community service. Can we just make it to the supervision of probation is only 2 years? You only have 2 years supervised probation, then it's not. Perfect. I was gonna show you this.
Yeah, I did see that. And
Okay.
that's his fortune. It's in there.
What other
Yeah,
courtrooms
we're
are
just
you
not gonna
in?
contest it, otherwise I don't
So
imagine. you
currently,
can,
the main two
because-
forums I'm in is yours and Judge Lethbridge. I was previously also in Judge
Okay.
Whitaker's courtroom, and I'm still in there, but I just have to finish up the cases that are currently on my case.
The goal is to just have you on the 2 judges.
Correct. It's my understanding that the sort of full-time conflict defenders, they want to only have 2 courtrooms. And then they have been outsourcing some of the other courtrooms to some of the private attorneys.
Oh, you have your red book.
Yes, I believe it is 5.
I'm gonna just double check. I know the max is 30 because that's what. My clients. Yeah.
He's obviously not a father.
Not at all. Not looking to come in. No,
No, that's
I'm
not right
a
either.
lawyer, not a
Now that I
man.
think about it, that's not right either.
What is it?
Trying to figure out.
We just do 90 days, though.
All right, Joe, come here for a second. So,
We'll try to have it on.
okay, your math's not good either.
6 months.
Okay, I know that much, but when would that?
April, beginning of May.
You there?
Yep.
Oh, for some reason I-
When you're a shadow for somebody, that mean they can just call you and get advice?
Well, in my particular situation, he does not want advice, except selectively. But what I understand my duties to be is that I am purely an advisor to him. In that, like, I'm not filing any motions or anything like that. I can just tell him, advise him on what I believe he can do. So I guess under those parameters, he could call and ask for advice, but I don't have any obligations.
We're talking about a different case. A different hypothetical. Because the case law that I read, I mean, sometimes they get appointed for trial and you're really there just for procedure. You
And was that standby counsel?
Yeah.
I hate that.
bills for my clients.
Because your bar card is still kind of attached to it.
Well, but I was just saying, I did see a situation where they brought in a defense attorney at the last second for standby, more for procedure.
Yeah,
Of course, then they try to hit it with ineffective, but it was overruled because they lost that claim because they were just really there for procedure and brought it at the last second. What? I don't even know about it. I don't even know about it.
Start being her best friend.
But we still need to have the real quickly, this is off the subject, but I know President wanted, or Clark needs, want to have a hearing on his removal.
I just want to make sure.
I mean, we need to do it for Reddit.
That's what I said.
Let's get.
Yes, you've got 2 older convictions, so I just want to make sure that you are. They're old, it doesn't affect anything, I just want.
Right.
This is, I guess it's not copy of the job. I defend
So
it.
you don't have any probation.
One day I want the DD, the next day I don't. Today I want it, next day I don't. It's weird.
Yeah.
In criminal, of course, you have all the
It's not
constitutional
going-
landmines. You want to
It's not
treat people right, but something.
Have you already had the serenity?
No, because whenever we're about to do it, she decides she wants her DD.
I mean,
It's
Yeah, I think Judge Lethbridge, because we're having this issue right now, and especially because,
The sovereigns don't ever want one.
well, he selectively wants. it. And so right now he's going through a competency evaluation. So that's completely different.
Okay, well, this is not what we have at hand now. So Ms. Jones, which one? Are we starting with yours first?
We can do them at both.
Okay, let's do them at the same time. That's right. They're co-defendants and it's the same facts to stipulate to. And come on up, Mr. Bridges.
I guess to my right.
Appreciate your efforts and efficiency. So,
You wanna-
yeah, come on up.
You tell me how you want.
I'm just gonna stand over here. Just, Mr. George. You can just put that there.
Council, you can stand in between. And then you here, and then him right there.
There you go.
Okay, so this is 22 SC 182-701. We have Maximilian Jordan and LaGuardia. Is it LaGuardia? Pardon me? LaGuardia Watts. And they are present in the courtroom with their attorneys, Ms. Jones and Mr. Hornsby Wilson. And we have Mr. Bridges with the district attorney's office. Mr. Bridges, you have a negotiated plea to present?
Yes, we have a negotiated plea for your consideration, Your Honor.
Okay, go ahead.
Okay, we're gonna do ladies first. So I'll ask her the question, she'll answer first, and then Mr. Jordan, your answer, okay? All right, so please raise your right hands. Do you swear or affirm that the testimony you shall give in this matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay.
Yes. Yes.
State your true and correct legal name.
Maximilian Jordan.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine? Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
I'm on the medicine.
You gotta speak up for me, sir.
I'm on the medicine.
Your Honor, just.
I'm
for
on
the
a
record,
seizure medicine.
Yeah, he has epilepsy. He is current on that epilepsy medication, but he does not have any mental health issues and is not on any medication.
Take your medicine this morning, Mr. Jordan.
Yes, ma'am. Yes, sir.
That's fine. Is there anything about that medication or your current condition that would affect your ability to understand the proceeding today?
No, sir.
Does it have any effect on your ability? I'm gonna ask you that already. Okay, is there any other medication that you normally take that you have not taken today?
No, sir.
Ms. Watts?
No, sir.
Okay. How old are you and how far have you gone in school?
32 in 12th grade.
Did you complete the 12th grade?
No.
Okay.
I'm 41 and I started in 12th grade. I'm 41 and I stopped in 12th grade.
So you did not complete high school. So neither one of you completed high school. Are you able to read, write, and understand the English language?
Yes.
Yes.
Do you understand that you are charged with the following offenses: traffic of meth and possession of a firearm to the commission of a felony?
Yes.
That's just what the-
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Yes.
Have you received the waiver of rights form with your attorney and reviewed it and signed it?
Yes.
Yes.
Have you had enough time to speak to your lawyer about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Yes.
Do you need more time to discuss the case with your attorney?
No, sir.
No.
Are you satisfied with your attorney's representation?
Yes.
Yes. Counsel, do you waive formal reading of the indictment?
So waived.
We do.
Do you waive any and all defects of the indictment, including anything with respect to the name?
So waived.
We waive.
At this time, the state is unaware of any warrants related to these charges. Counsels, are you aware of any outstanding warrants related to these charges?
No.
No.
Has your attorney advised you of the maximum minimum sentence of the charges that you are pleading to the possession with intent to distribute and the possession of firearm during the commission of a felony?
Yes.
Yes. Do you understand the minimum on the drug charge is 5 years to 30 is a max?
Yes.
And the gun charge is 5 years to serve consecutive to whatever other charges you have?
Yes.
Yes. Do you understand that if you are sentenced as a recidivist under, I'm sorry, apologize. Do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 10 years probation on the drug charge, 5 years to serve on the gun charge suspended? Do you understand the court does not have to accept the recommendation? The court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
Yes.
Yes. Do you understand that if your guilty plea is, I'm sorry. Do you
But both of these are the same recommended sentences, correct?
Yes, sir. Except
Okay.
I think everything's the same.
All right.
With the exception of she's taken hers under conditional discharge.
First offender. Do you understand that this plea may be used to enhance sentences on other conviction in this jurisdiction as well as other jurisdiction, including the federal court?
Yes.
Yes. Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on entering a guilty plea today?
Yes.
Yes. Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or special conditions of probation without being subject to revocation of the balance of your sentence?
Yes.
Yes. Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Yes. Are both of you the United States citizens?
Yes.
Yes. Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Yes. Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes.
Yes. Ms. Watts, I understand you want to enter your plea under the first offender.
Correct.
Are you asking this court to treat you as a first offender under the provision of the First Offender Act?
Yes.
Have you ever pled guilty or nolo to or been convicted of a felony in this state or any other jurisdiction?
No.
Have you ever been sentenced of any felony of any crime, felony, or misdemeanor under the First Offender Act?
No.
Has your attorney explained to you the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of the first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked? You could be adjudicated guilty and you could be resentenced to the maximum sentence on each charge.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a guilty plea today?
Yes.
Yes. Do you understand if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or remain silent and not incriminate yourself?
Yes.
Yes. Do you understand by pleading guilty, you are giving up the following rights? The right to a trial by jury, the right to remain silent, not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or court-appointed counsel if you cannot afford an attorney at trial, the right to presumption of innocent, the right to testify on your own behalf and present evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, the right to appeal the convicted of these charges at trial.
You can continue, I'm sorry.
I didn't need, you need me to repeat that?
Yes, please.
Okay. You understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent, not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or court-appointed counsel if you cannot afford an attorney at trial, the right to presumption of innocent, the right to testify on your own behalf and present other evidence, the right to subpoena witnesses and compel the production of evidence, and the right to have the charges against you proven beyond a reasonable doubt, the right to appeal the convicted of these charges at trial. You understand these are the rights you're giving up by entering a guilty plea today?
Yes.
Yes. Has anyone forced, threatened, or promised you anything to enter a guilty plea today?
No.
No. Is it your decision to waive your rights to enter a guilty plea because you are in fact guilty?
Yes.
Yes. How do you plead to the charge of possession of controlled substance with intent to distribute and possession of a firearm during the commission of a felony?
Guilty.
Guilty. Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Yes, sir. Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Yes, sir. Do you understand that you have only 4 years from today's date for a felony charge to file what we call a habeas corpus challenging the constitutionality of this guilty plea?
Yes.
Your Honor, based on the events on July the 12th, 2020, officers responded to 2010 Ruth Street, Northwest Atlanta, zip code 30318, that's in Fulton County, regarding a shooting. When they arrived in the location, they found 2 individuals in the front lawn of this address who had been shot numerous times. They aided those individuals and actually sent them to Grady. Upon an investigation, they attempted to speak to the defendants. The defendants were not cooperative. And doing their independent investigation, they found several gunshot shells in the yard of the house and on the front stripes on the house. In addition, they found an Altima in the front that had been struck by gunfire, and the house across the street had been shot by gunfire. Individuals said that a Dodge truck drove by, black Dodge truck drove by and began firing, and there was a return fire. Officer obtained a search warrant for the location. When they entered the location, they found drugs and drugs and guns in the location. At that point in time, they charged the defendants with the above charges. Your Honor, the state is recommending 10 years to on count 1 to the reduced charge of possession with intent to distribute, 10 years probation. On that count, on count 2, the possession of firearm during the commission of felony, 5 years to serve suspended. They are to have no drugs and alcohol. They are to do a drug and alcohol evaluation and follow any recommendation. They are to have no weapons, including guns or replica. They are to maintain gainful employment. If they do not have gainful employment, they are to do community service in the amount of 20 hours of community service per week. And for Ms. Watts, I think she's going to start her community service or employment in May of 2024. Is that correct?
Yes.
Okay. That's all I have, Your Honor.
Before the drug and alcohol evaluation, what was the special condition before that?
Probably no drugs and alcohol,
Oh, okay.
unless prescribed by a doctor.
Pardon me, Kathy? Did you say something about forfeiting?
Yes, Your Honor, I did say forfeit asset forfeiture, but it had already been done previously by the law enforcement.
Okay. And then the 5 years of service suspended, that has to be consecutive, right?
Yes, Your Honor, that is consecutive.
All right, Mr. Wilson.
Good morning, Your Honor. I have before you Ms. Watts. We just ask that you accept this negotiated plea as a conditional discharge under 16-13-2. I know they're very similar between that and first offender, but I believe conditional discharge is tailored specifically for drug offenses. Additionally, we would ask for a behavioral incentive date of 3 years. Other than that, my client has no criminal record, which is why she's able to take the conditional discharge. And I do not believe that this will be a repeat offender of any sort, as she's just looking to accept responsibility and move forward with her life.
Correct me if I'm wrong. Don't they already have the right to come in after 3 years?
I believe so, but I think it just, in the record, it would be nice also.
Do you object to that?
Your Honor,
Mr.
I actually would like it 4 years because remember, we're pushing her back to 2024 before
Okay.
she starts in 3 years.
I think that's fine.
Okay. All right, Ms. Jones.
Thank you, Your Honor. As my client indicated, he's 41 years old. As noted on the record, he does suffer from epilepsy. One of the conditions that the state had was that he worked, but he cannot work at this time given doctors' recommendations because of his epilepsy. So he's agreed to do the 20 hours of community service work. And at some point, if the epilepsy stabilizes, he can find employment. But at this point, he's opted to do the community service. In terms of the facts, Your Honor, we've negotiated this. So we do request that you accept that recommendation. I would note that it was Mr. Jordan who actually called the police when there was the person who was shot. He actually, in the defense's position, actually cooperated with the state. I know it indicates in the search warrant he didn't, but actually in the police report, it does indicate that he was able to provide a description of the car and some of the men who got in that car after this scene. He felt the shooting happened down the street. The police weren't necessarily sure, but I'm sure given in chaos when you're in your house and you hear some gunshots, you might not necessarily know exactly where that happened. The police then got a search warrant to search my client's house for evidence of a shooting. However, it quickly evolved to looking for that to basically a fishing expedition in regard to my client, which is why we filed a motion to suppress. However, in speaking with the state, they noted some of our concerns, which is why they agreed to reduce it. When the police are looking for people to cooperate in investigations and then turn that investigation on its head and then seek out the people who are the very people who call the police, can cause issues with the community, which is another reason why we voiced our concern as well as the motion. But I do think that this is an actual fair resolution, Your Honor. We are satisfied in regard to this. And as the state indicated, asset forfeiture had already happened a little over a year and a half ago. So that decision is final and there's no way for that to be appealed at this time. So we just respectfully request you follow the recommendation.
Do you want the 4-year behavioral incentive date as well? And you're,
Well, under law, they're entitled to petition the court to terminate after 3
Okay,
years of supervision for 2. So I don't oppose it, but I did note from my client that if he does all the things he needs to do, he can petition the court after 3, subject to the state's consideration. But if the state is inclined for 4, okay.
Your Honor, the reason we asked for 4 on Ms. Watts is because she's not starting till May of 2024.
that's right. You said that. All right. So we won't even address it then with Jordan. He's got the right to. Okay. All right. So I've got a few questions and I'll do them individually and I'll start with Ms. Watts. So do you understand the nature of the charges against you?
Yes.
You have just heard the district attorney explain all the rights, the assistant district attorney explain all the rights you give up by this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes, sir.
Do you understand the court is not bound by the recommendation or the plea agreement? I can sentence you as I deem appropriate.
Yes, sir.
Are you pleading guilty because you are in fact guilty?
Yes, sir.
Mr. Hornsby Wilson, are you satisfied that your client is competent and understanding that the plea is voluntary and there's sufficient factual basis for entering the plea?
Yes, Your Honor.
Okay, Ms. Watts, the court finds that you understand the nature of the crimes and consequences of this plea. There is a factual basis for the plea, and the defendant has knowingly, intelligently, and voluntarily entered this plea. The defendant has requested a sentence under the Conditional Discharge Act. The court will approve that request, withhold adjudication, and does hereby notify the defendant that this plea may not be withdrawn in the event the defendant fails to fully comply with the terms of the sentence I'm about to impose, which is the recommended sentence of 10 years. Well, the first charge is downgraded to possession with intent to distribute, and you'll have 10 years probation. The second charge is 5 years to serve consecutive, but that'll be suspended. You're to have no drugs or alcohol. You're to have a drug and alcohol evaluation and follow the recommendations. You're to have no weapons or any sort of replications of weapons, including firearms, and you are to maintain gainful employment. And if you do not maintain gainful employment at a minimum, you are required to do 20 hours of community service, and you'll have a behavioral incentive date of 4 years. Is that everything on Ms. Watts?
It's 20 hours of community service per week.
20 hours of community service per week. Thank you for clarifying that.
And that's
Anything?
just to start in May of 2024.
And to start in May of 2024.
Yes, Your Honor.
Anything else on Ms. Watts?
No, Your Honor.
All right, let's do Mr. Jordan then. Mr. Jordan, do you understand the nature of the charges against you?
Yes, sir.
You have just heard from ADA Bridges explain all the rights you give up by this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes, sir.
Do you understand that the court is not bound by the recommendation of the plea agreement, and I can sentence you as I deem appropriate?
Yes, sir.
Are you pleading guilty because you are in fact guilty?
Yes, sir.
Ms. Jones, you satisfied that your client is competent and understanding, the plea is voluntary, and that there is sufficient factual basis for entering the plea?
I do. I am, Your Honor.
I find there is sufficient factual basis for the charges. I also find your plea of guilty to be knowingly, voluntarily, and intelligently entered. I will accept your guilty plea and sentence you to the recommended sentence, which is count 1 is downgraded to possession with intent to distribute. That'll have 10 years of probation. Count 2 is 5 years to serve consecutive, which will be suspended. And you are to have no drugs or alcohol. You are to have a drug and alcohol evaluation and follow those recommendations. No weapons. You are to possess no weapons or replication of weapons, including firearms. And you are to maintain gainful employment. Your attorney said that that won't be possible immediately. But regardless, if you do not maintain gainful employment, you are to perform 20 hours a week of community service work. Is there anything else?
Not on the part of Mr. Jordan.
Not for the state, Your Honor.
Okay, well, you're both excused.
Yes, sir. Thank you.
Okay, perfect.
Oh, I didn't even fire up my Zoom, so,
Okay,
all right.
I wasn't aware. You still have my.
There you go.
Here's my phone.
Mr. Bridges? Can I ask you a couple of questions?
Yeah, why don't you come back to my chambers when you're done, Mr. Bridges, if you've got a minute.
We're done?
We're done.
Okay. Ms.
Nice
Cullen,
meeting you.
Ms. Marham, we're done today.
Okay,
Okay.
well, this is going to be the easiest one,